You've heard plenty about the importance of funding your living trust, right? But did anyone ever tell you there are certain assets you should never put into your trust? Stick around, because today I'm going to reveal exactly what those are and how to avoid costly mistakes. Question 1. Should you transfer vehicles like cars, boats, or motorcycles into your living trust? Surprisingly, no, and here's why. First, vehicles usually transfer easily without probate. All you typically need is a death certificate. Also, placing vehicles in your trust can expose your entire trust to lawsuits. Imagine a minor accident turning into a legal battle against your trust, risking your home and savings. Lastly, insurance companies often complicate or even refuse coverage for trust-owned vehicles. So skip the headache and leave your vehicles out. Question 2. What happens if a trust-owned vehicle is involved in an accident? Great question. If your trust owns a vehicle involved in an accident, attorneys can and will name your trust as a defendant in lawsuits. Suddenly, all your carefully protected assets could be vulnerable to judgment or settlement. Keeping vehicles titled personally is safer, smarter, and protects your overall wealth. Question 3. Why is vehicle insurance tricky with trust-owned cars? Insurance companies simply aren't set up for vehicles titled in a trust. They struggle to issue coverage, leading to delays, denials, or inflated premiums. Unless anonymity is a major concern, save yourself the stress and keep your car insurance straightforward by titling vehicles personally. Question 4. Should annuities, IRAs, or 401k plans be placed inside a living trust? Definitely not. IRAs, 401ks, and annuities already bypass probate through beneficiary designations. Transferring these into a trust triggers immediate taxation. Ouch! It could even disqualify your special tax advantages, potentially costing thousands in taxes. Instead, use beneficiary designations wisely to route these assets effectively through your trust after your passing. Question 5. What big mistake do people commonly make with retirement accounts and estate plans? One huge mistake I see frequently is naming young kids directly as beneficiaries of retirement accounts. Imagine a 21-year-old inheriting $500,000 outright. Probably not the best idea. Instead, name your trust as beneficiary, allowing your trustee to control distributions responsibly, ensuring your heirs benefit long-term rather than making youthful financial blunders. Question 6. Why shouldn't your life insurance policy be placed directly into your living trust? Here's the deal. Life insurance proceeds already bypass probate with simple beneficiary designation. Putting your policy in your living trust is unnecessary. And in states with lower estate tax thresholds, it can even result in higher estate taxes. Instead, consider designating your spouse or trust as beneficiary, keeping the funds safe and tax efficient. Question 7. When might an irrevocable life insurance trust, ILET, be beneficial? If your estate is substantial, let's say over your state's estate tax threshold, placing life insurance into an irrevocable life insurance trust, ILET, makes sense. It keeps large payouts outside your taxable estate, significantly reducing estate taxes for your heirs. It's a strategic, advanced planning move worth discussing with your estate attorney. Wrap up. Remember, properly funding your trust is essential, but knowing which assets to exclude is just as critical to your financial security. Protect your legacy wisely, keep vehicles, retirement accounts, and life insurance carefully managed outside your trust. Like and subscribe for more crucial tips on protecting your assets and ensuring your family's future.